Okay. Good. Good morning, everybody, and welcome to Continuing Professional Education Services Hot Topic for the month of March. Can't believe it's March already. What I am going to do, and I'm Phil Brilliant, I am just going to be a moderator today.
Somebody's got to mute.
And I'm going to mute everybody real quick.
All right.
Okay. And I just muted you all, including the speakers, so the speakers can unmute themselves. We are going to kick in. I'm not going to give a big long thing. I'm going to introduce Dr. George Berkowitz as soon as he unmutes himself. And he is going to be the moderator and start this off. We have a great panel discussion on independent professional judgment today. And George, it is all yours.
Okay. Aside from Neil Rivers, how many people know what the $1 Million Quartet was? The $1 Million Quartet, and this is true occurrence, and you can video it. On December 4th, I think it was 1956, that Sun Studios in Memphis, Tennessee, owned by Sam Phillips, who had Elvis Presley, Jerry Lee Lewis, Carl Perkins, Johnny Cash, all under contract at one time. And they showed up serendipitously unexpected. And they recorded 17 songs. This was known as the $1 Million Quartet. I am glad to introduce you to the 2995 Quartet, which is comprised of Joanne Voss, Roger Ferguson, Andy Robbins, and Neil Rivers. Joanne Voss from Arizidi Falcone, Roger Ferguson from Penn Jersey, Andy Robbins from Sills Cummins, and Neil Rivers from that wonderful consulting company, Langham.
What's the decimal go in that number, George? And is that
can I, for the record, say Joanne's 2998 of that?
Well, when Irene showed up, it went to 3525. So thank you, Irene. Irene is a special guest that wasn't listed. And amongst Andy, Irene, and myself, we were there for the original stakeholder groups. We were there for the evolution of the LSRP program. And therefore, I think that our opinion, more than others, is probably important relative to perspective. But I want to get this thing started. Let me just give you a quick background. We've been beating the drum on this for a while now, maybe over a year and a half, maybe even close to 2 years, about the erosion of independent professional judgment, which is paramount in how the LSRP program is supposed to work. Absolutely. Not without its problems, not without some fine-tuning, but it is a basic premise, a basic foundation stone on how this program is supposed to work. Recently, we got the attention of Assistant Commissioner David Hames, who convened a meeting of impacted individual groups. And I believe there were 13 presentations presented on, I believe, my birthday, February 22nd. I'm 39 years old now, times 2. So with that said, what happened here was David asked for each group to present a white paper prior to a 10-minute presentation during this this Zoom call. It was a team call, actually. So with that, they committed to getting back to us based on what they heard. That meeting has yet to be scheduled, but they asked us for a white paper. We in turn asked for them to give us a white paper and to tell us what they think of what they heard. This was a one-way conversation. DEP never responded to anything, and I'm glad that happened because at least it gave us an opportunity to vet what some of our concerns are. So I want to read to you one of the preambles of a paragraph that was given to DEP. We fervently believe that the current process, I can't even read it, fraught with inconsistencies, lack of experience, and/or misunderstanding of the role of the reviewer, more than is specified in SARA, and more importantly, the mistrust of LSRPs. To that end, we have convened a panel this morning to talk to you about what their perception is about the potential erosion of the independent professional judgment. I gave us one of the seminars I gave regarding independent professional judgment. I passed out a questionnaire, and it was just yes and no answers. Was your reviewer well versed in the applicable regulations? Was your reviewer well versed in the technical and scientific issues involved in your permit application? Did the reviewer threaten you? Was your reviewer willing to examine differences and try to establish a better understanding of the position of the LSRP? And was your viewer well-versed in the role of professional judgment? And most of these answers came back, as you could expect, no, 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 no. So with that, I'm just going to ask Andy, if you could, because you were there, if you could just give us a quick summary of what the independent professional judgment was supposed to be in the LSRP program according to Sarah.
Sure. When we went through the stakeholder process that Irene so ably led, there were a lot of discussions about the problems with the program and where things were going. And eventually there was an understanding that there was going to be a big change, a sea change, as a lot of people described it, in how cases were managed on a day-to-day. Gone was the DEP case manager. Moving forward, there would be the LSRP. And there was a certain amount of recognition by, I think, everyone, particularly the regulated parties, that there would be a limited ability for some people at DEP to accept that the LSRP was, for want of a better word, in charge at least on the day-to-day. And a critical aspect was the burdens that were placed on the LSRP to document their work, to focus on protection of the human health and the environment, to not accept direction from anyone that was inconsistent with their protection of independent professional judgment, and that they would use that independent professional judgment with the skills that they had. And the limits were placed on who could be an LSRP based on education, but more importantly, experience with site remediation cases, site remediations in New Jersey. There were requirements put in where people were highly qualified but couldn't be LSRPs because they didn't have experience with New Jersey's regulatory program. So one of the core aspects that was put into SARA was that absent an indication that the remedial approach used by the LSRP was not protective, the LSRP decision remained, period. Not, there was a better way to do this, I would have preferred a different approach. Hey, you took 6 samples as opposed to 8 samples, as opposed to 12 samples, as opposed to 4 samples. Was there a approach used that's protective? And if the department had information that it wasn't protective, the department had power to act. If there was bad work done, but still protective, that's something that the board would have to address in disciplining LSRPs and how they went about their business. Mm-hmm. The analogy I draw is if you go to DMV to get your car inspected and you have 16 parking tickets that are unpaid, someone might notice that on the inspection. I doubt it, but they could, but they still inspect your car, and if your car passes the inspection, you get that inspection sticker, and you might get referred to a lot of other people. Hey, at the end of the line, the police might show up to collect on the tickets, but at the car gets inspected. The same thing with the remedial approaches. And we knew that there were people in the department that were not on board. In fact, I remember when we were called in, a couple of us, to have a session with the department staff about how the process would work. There were a number of DEP people, and I give them credit for the vehemence of their conviction, that got up and said, we don't like this. And one of those people, by the way, who's just retired, was put in charge of training new staff on how professional judgment's used. So what we're seeing now is the department concerned about crappy submissions, some of which there are, and there's really no great excuse for a lot of those, if any of those, but not focused on absent information that we have that the remedy is not protective. we have to let this go forward.
So let me, where did we go wrong with this? We started out with a program under Irene and then with Dave Sweeney and things were going the way they were intended. What happened? Roger?
Well, first off, I had to button my top button. I was feeling underdressed. So, this started to happen, in my view, the summer before Governor Murphy's election, when it was obvious that Lieutenant Governor Galdano was being thrown under the bus and was not a viable candidate. That's when I noticed the pendulum started to shift. And I don't claim to understand all the reasons, but I think part of it was, if you remember, under Mr. Sweeney, the Department of Site Remediation was completely reorganized to take on their new roles and responsibilities. And I think some of it was natural assertion of bureaucratic privilege by these new groups: Bureau of Inspection and Review, Bureau of Remedial Action Permitting, other groups, you know, in the way that documents were parsed out. And I'll agree with Andy, we've heard stories of bad submissions. But I should only point out, there's only been 2 LSRPs who've lost their license via board action. And very few documents that have been invalidated by the department. And those invalidations have been primarily because the LSRP was no longer an LSRP.
Yeah. But Roger, let me just focus though. In your opinion, there was a change in how the department perceived the submissions. Am I correct?
Yes, absolutely.
And where did that manifest itself most importantly?
Well, it's manifested in, first, you know, the permitting program first and foremost. And I think we should delve back into, you know, what was that supposed to be? But it also shows up in Bureau of Inspection and Review. A key part of it is loss of experience.
Yeah.
You know, at the management level, who would, you know, provide direction to staff and were willing to manage people, the Len Raminos of the world, the Wayne Howitzes of the world, who understood the program and supported the program. You know, they weren't there to have a conversation with and say, you know, Wayne, this is still protected because, and Wayne would get it and Wayne would fix it. I think Andy and I got the very first remedial action permit for soil with Wayne. It took what, 2 days? You know, now we're at almost 2 years. So, you know,
let me ask Neil. Neil, how are you doing with remedial action permits?
Look, I think the remedial action permit program struggles, and LSRP submitting applications in many cases struggle in getting the permit on a timely basis. As it's no secret, I've been a member of the stakeholder committee involved with that remedial action program, permit program with the department now for 5 years. Trying to make forms easier to interpret, make sure questions are more clear so that submissions provided by LSRPs are more understandable to the department. At the same time, I'll say that you know, that the department, in my opinion, and some of the questions in those forms and some of the aspects of the guidance, the department establishes their own perspectives, opinions, in a way that that sets up an opportunity for the department's professional judgment to trump the LSRPs.
So I'm sorry for interrupting, because I do want to spend some time on the reviewer's qualifications to do that, but not.
Hi, George.
Yeah.
Hi, it's Tony Russo. I joined by phone. Can I just kind of weigh in on what was just said? Because the day after our call, David Ames presented at our Superfund site. So he and I had a sidebar conversation at the end, and I said, David, what did you think of the call? And he said 2 important things to me, which I wanted to share with the group. He said, look, Tony, I was holding back. I really felt like jumping in because I know it was a listening session, but he can't get away from the fact that there have been submittals through the years that have been so egregious, I guess, that they keep focusing on the bad stuff and not the good stuff. So that's
Okay,
one
so
thing.
now I'm gonna jump in. I'm sorry to
Wait,
interrupt
but
you.
one
Go ahead.
more thing, George,
Yep, go
because
ahead.
it's related. The second thing he said, which I thought was really interesting, he's like, Tony, I never want to get a call from anybody from the outside, where they say that the reviewer said in his or her opinion, that in their opinion, and he used those words, in their opinion, they disagreed with the LSRP. So the question I have for all of you is, do you think the reviewers that are at the department would actually pass an LSRP exam if they were given that exam? Because to
Well,
me, you should basically review your peers' work, right? So if you're an LSRP, you're basically, I guess, qualified to look at another LSRP's work.
Tony, I'm going to interrupt. I can't tell you how disappointing that response is. That to me is so defensive and so myopic to be absolutely deficient in his role, what is supposed to happen. I don't believe he can be objective at this point. And I don't want to attack David. I like David. But I will say, quite frankly, yes, there are going to be problems with certain LSRPs. Any community is going to have some outliers. And if he focuses on the outliers rather than the routine, there are ways to deal with that. If the LSRP is so deficient, file a complaint to the board and attack his license. But don't hold permits hostage.
So George, I guess one of the recommendations I would make to this group, and I've received a few emails from a couple of the coalition members after, is the way we presented those cases to them at their listening session. We should ask them to present cases where they felt were so egregious, so we all are on the same page. Like, okay, David, now it's your opportunity to share with us the cases that you guys all believe were cases where, you started to question the professional judgment.
Andy's shaking his head no, and I am also shaking my head no. Let me do it
Yeah,
now.
yeah,
Go ahead, Andy.
I'll just jump in. We need to distinguish between three things. One, crappy submissions, which should be addressed in the ways that the department has the discretion to be able to go after the PRCR, the person responsible for conducting the remediation, if the work being submitted is that deficient and violates a rule. B, against the LSRP for submitting repeatedly deficient or egregiously deficient work. And the failure to recognize independent professional judgment. There are legitimate reasons that the department could say, listen, I'm not comfortable. You didn't tell me how you address this receptor. And that goes to the qualifications, the reviewers and whatnot. And those should be elevated to a supervisor immediately before a newer, less experienced person asks that question of an LSRP. But I am tired of the department deflecting their inability to recognize that the LSRP's judgment controls absent evidence that the remedy is not protective,
Right,
by saying we keep getting crappy stuff. The crappy stuff is a concern. And I heard that he was, the session on last week was everyone was limited to 10 minutes. And you can tell we can go on for a while on this. And the department was upset that people didn't go into the crappy submissions. It's a separate issue entirely. And
so
conflating the two gets us nowhere.
let's hold off, because I do believe a significant part of the discussion should say, what's the root cause of the problem and what's the solution to the problem? And I want to get to that, but I want to ask Joanne a question just before we get there. Joanne, you're hearing a lot.
George, just so you know, Neil has been patiently with his hand up for a while.
Neil, go ahead. Go ahead. Neil,
I just want to say one thing, and feel free to take it to Joanne. I looked at the metrics that were provided at the last SHRAG meeting. The department acknowledges 19,700 RAOs under this program. We're about to hit 20,000. And I dare say there weren't that many NFAs issued in the 10 years before. 19,700, 24 of those have been invalidated. This is not 631 have been withdrawn, which means there may be some administrative, there may be some technical, but we're talking 99.8% valid RAOs
Yeah.
I'll yield the time.
And I'm just going to go to Joanne in a second, but I do want to simply say that there is a selective bias in their storytelling. And their selective bias is always bent on telling the worst stories. And there are ways to handle that, as we are going to discuss later. But I do believe, I am so sorry to hear that David is so freaking defensive. He's not being objective. I know Gwen Zervis is being objective, but David isn't. Okay, Joanne, what are some of the consequences, particularly relative to redevelopment? When we go into the department and we do, we submit preliminary assessments, site investigations, RIs, then we come up with, it's not going to be clean, so we have to go for a remedial action permit. How long does that remedial action permit take? Not asking you to talk about that, but what are the consequences of having this iterative process at the end of the day, at the end of the story? What does that do to redevelopment in your communities?
I'll tell you, I mean, it's a stymieing process, actually. I represent municipalities all over New Jersey in redevelopment. And Joe Mariziti has always taught me environmental remediation is a huge component of redevelopment. And so our redevelopment agreements always, in a lot of detail, talk about the remediation obligations of the redeveloper, because sometimes they're redeveloping sites where the responsible party is nowhere to be found. And so in that process, we require remedial action permits, RAOs, all those finishing documents, I'll call them, to be provided to the municipality at the end of the redevelopment so they can get their certificate of completion. Certificate of completion is something that is required by and involved in, the local redevelopment housing law. And so that certificate of completion, if you don't have it, the redeveloper can't transfer the property. And that is often a huge financial problem for a redeveloper. So Andy knows we've been on the other, opposite sides of the table. We've had to come up with ways to kind of get around that because we don't want to stymie a redeveloper. We want to encourage, obviously, redevelopment, and we don't want to stand in the way. So we've had to find ways in some cases to get around it. But in certain cases where there's, legacy contamination and things like that, before the town will issue a CO, we agree. I mean, we can't control, obviously, an officer or a construction official, but we agree privately with the redeveloper, you're not going to seek a CO until you give me some final remediation document. And so, what has happened in some very bad cases, you have a project ready to be occupied and it can't be occupied because documents are taking a long time to get through the system. And so then, sometimes we find a way to amend the agreement to get around it. Or sometimes we just wait, it just depends on the situation. But the delay, this delay is substantial. I was shocked to hear any permit was issued in 2 days. Interesting. Way back at the process in the beginning of the process, I guess. But yeah, that's definitely not been my experience, obviously. And yeah, we've had to account for that.
Right. One of the externalities of this back and forth is eroding public trust in this program. We started off on the right foot. Things were moving swimmingly. Everybody was getting things done. Sure, there were some outliers. Sure, we had some bad submissions. Sure, we'll continue to have some bad submissions, but you can't focus on them. What you need to focus on is the 180 degrees the other way. How is the department doing their job? And are they doing it correctly? So here, let me do a jump ball here. We believe that this program needs to be fixed. The question becomes, how willing is the department? How willing will they be to listen to us when we identify some of the root causes of what these problems are? So I want to get into the root causes of what we think some of the problems are with the reviewers and how that manifests itself. Neil, you want to give that one a shot?
Well, I'm going to say that the root causes with the reviewers, in my experience, and I think they're trying to do God's work and trying to do it well. the root causes are I think they've been either trained or permitted to exert a significant amount of their professional judgment into the equation. And so as a root cause, and I think, George, I know part of the efforts that you've been working on is sort of train the reviewers, go through that process. I think ultimately all of that has to come from top down. If your boss says,
Yeah.
this is what you do, then that's what you do.
Right.
If you're having a meeting with your manager about a prospective case and that manager says, is that LSRP wrong? Are you sure they're wrong? Are you sure it's not protected? And the answer is no, but I believe. Well, then that manager needs to say, but Sarah says that the judgment of the LSRP trumps your judgment. That's
So, if I could interrupt, Neil, I think you were pretty strong on our pre-call about somebody second guessing your professional judgment, particularly technical judgment. You want to address that at all?
well, I mean, look, I think, again, I think that's fundamental to the program. The example I used was a discussion about the thickness of a cap and what should a cap configuration be. And the department in the stakeholder process was presenting their opinion. And my response was, is anyone on this call a professional engineer? Because a professional engineer understands what type of cap material and how thick for that material to be suitable for its intended use and durable under normal wear and tear. And we as LSRPs are obligated to utilize individuals outside of our specific discipline if that's necessary. And so, so that was my argument back. My argument was that the thickness of this cap determined by a professional engineer has proper technical standing.
Yeah. So let me put
Hey,
this
George,
over to
jump in,
Roger and
George.
Andy.
George,
Go ahead, Phil.
George, can I jump in 1 second? Roger's been patiently waiting with his hand up for a minute here.
That's not like me.
Point that out there.
I'm going to Roger now.
Okay.
Same
But
concept.
before I do that, Roger, I just want to, I want you to segue back into this. What's the quality control of the individual reviewers' decisions? Go ahead, Roger.
That's something I had written down, George, and I'm gonna harken back to the old days because I'm getting old.
Yeah, I haven't hearkened in a
You would get a
while.
letter from the department and it would be signed by George Barkowitz, but it would say, please call Richard Katz if you have any questions, which meant that Dick wrote the letter and George approved it. That doesn't happen anymore. You get a cryptic email from somebody on staff, and I'll use the case study that I presented to the stakeholder group the other day. And I got an email from somebody with 4 months experience in site remediation saying that my remedy related to the off-site commingled plume coming onto my client's property was not protective. When we had done a significant technical consultation with the director levels in the building, but that person never bothered to look at that. This is definitely a training issue. And I know from my own experience, and when I'm talking to somebody else just yesterday, they're trying to look at every document ever written.
Right.
Okay. And they tell us, well, if we want to do that, we have to go through the same process as you and go through the Oprah office, pull them out of the dark, scary storage place. Therefore, we have to submit every document ever written electronically. So you're writing a permit at the end of the day to use that, and you've dealt with 32 areas of concern. They're already closed. They already have RAOs, but there's 3 left that you're addressing. We have people going back to look at the other 32 that are closed. No wonder it takes forever. But there's no direction from management. There's nobody willing to manage anybody in that building right now And I honestly, it's not just site remediation, it's the entire building.
Well, let me say this, and Andy, I want you to opine on this. It's
Okay.
my opinion that you hit the nail on the head, Roger. First of all, there's little training, there's little QC function of the department. There's no designated technique. I'm sorry, there's no guidance document for the reviewers that said, we have 42 guidance documents. Do they have any as to how to review a permit and what the consequences are? Is there a flow diagram? I think Gwen is putting together a
There
flow
is one
diagram.
being produced.
Is there
only now.
training? Is there training as to what the respective roles are? Have they read Sarah? Have they understood what the role of the LSRP is? This to me is so apparent that I don't know why it's not being addressed. Anybody want to, Andy, comment on that, please?
Joanne
Sure.
raised her hand though.
Okay, good,
Oh,
Joanne.
that's okay. Go ahead. I'll wait.
Okay, so
Thank you,
you
Joanne.
asked a couple of questions, George. I'm not sure there's no training. I think there's bad training. Okay, I think they're being told that the remedial action permit is the department's and that the department has to stand behind it and
Right.
the department has to be convinced and it's up to the department's judgment as to whether it gets issued, and that's crap.
Right.
Okay, maybe we made a flaw in our writing of Sarah that we didn't detail the remedial action permit because it was the only area that everyone agreed upon, that there should be documentation, that there are conditions at the site that people should be aware of going forward. And there's no recognition in what I see as the department's process that the remedial action permit has follow-ups. There are biennial certifications. There's a process to go through. I'm a reviewer. I don't like the independent professional judgment of the department. I issue the department. I tell them what my problem, the LSRP, what the problems were. If the LSRP stands by where they are, the LSRP and the PRCR's butts are on the line, and they can go forward with that. And I bet you most of the time, if not almost all the time, the LSRP is going to say, let me make sure I cover that in my own certification. Let me make sure I put a note in the file regarding that. Let me see how I follow up on that. But we have the department thinking that they're the ultimate issuer of the protectiveness of the remedial action permit,
Agreed.
and that's the flaw.
Agreed.
So, you know, and I just go back and to pile on with Joanne, it's not just redevelopment areas, which, as we said as was said by the department, I think it was Ken Klug, that 98% of remediated sites are a result of redevelopment. Okay, and which is why it's so critical. I have clients jumping through ridiculous hoops, getting RAPs on a building by building basis for 12 building developments so they can get Fannie Mae to approve loans to their new residents coming in. And then trying to put those all together and merge them at the end of the day, and 17 iterations of the condominium documents, because each time you have to fold in, not 17, but in that case, 11 iteration, you have to fold in the new building into the entire process to go through that. And then trying to consolidate the remedial action permits in the end, when, as Roger pointed out, and it was one of the case studies we presented to Senator Smith early on, as to the success of the program, in that case, we had a site where it was under development, an opening for sale was going to be June 1st. Sometime in late January, they discovered 4 tanks that were, I think it was 4 tanks that were previously uncovered with contamination that migrated from them. We got an ARS approval, alternative remediation standard, in 2.5-3 days. Roger was able to put everything together. We got the remedial action permit process. The project opened on time and it was protective and the remediation was completed. What we don't have now is staff. We have staff going into their own independent reviews of their judgment. We don't have support on ARSs. I don't know how long it takes to get an alternative remediation standard approved, which you need a department's approval for. I think there's one person doing them. We have no one in charge of ISRA. If you have an ISRA question at the site, because everyone else is retired, but we have enough time to nitpick and double check whether or not the department agrees with an LSRP's professional judgment.
Yep, thank you. Joanne.
Yeah, I totally agree. There are numerous, many properties in the state of New Jersey that are not designated as areas in need of redevelopment. They're not all going to come under redevelopment, obviously. But and maybe this is jumping the shark a little bit and getting to the conclusion. I don't mean to do that, but clearly, there's a view at DEP that LSRPs are the foxes watching the hen house, so to speak. And
Absolutely
so
correct.
it may not be that this ever can be changed internally. And I'm jumping off of a comment that my friend George Tyler made in the comments here. And I completely agree with him. It's something that's going to have to be dealt with at the legislative level. If you look at the legislative history of independent professional judgment, it's pretty strongly stated that there are decisions that the LSRP should be making without the prior approval of the department. So why can't LSRPs issue their own permits? I think the legislature is going to have to get involved at the end of the day.
Yeah.
And when we met with the legislature in Sarah 1.1, Joanne, that was discussed, and Andy was there, George was there, at length with Senator Smith. And Mark Peterson was in the room, and a promise was made by Mr. Peterson that we didn't need a legislative fix for the permits because DEP would do it under regulation.
Yeah.
We're now going on 3.5 years since the promulgation of the statute.
Right.
We have not seen draft language from the department.
But there, let me interrupt though. There's a couple of nuclear solutions that nobody wants to use. One of the nuclear solutions is filing a complaint to the licensing board about DEP preempting the LSRP's professional judgment. Now, Phil's laughing. I've got to tell you, I know one LSRP who's this close to doing that, and I'm going to feed him some drugs and he's going to do it.
I've been close on the case before, and my client at the end of the day decided the juice was not worth the squeeze.
But
Because we talked about it being nuclear.
But having said that, the other solution, quite frankly, and it's quite, I think it's remote unless we have the right team, Irene, read between the lines, going to Senator Smith on this. Because we need some gravitas. Tony, I don't know what your relationship is with Senator Smith, but it may be time to do it. And I think George Tyler, I didn't see what George said. I think he's actually on a dime here. There needs to be some legislative intervention here because I don't see it happening on its own. And Phil's going to call me. I've been telling Phil that he's a pessimist. Now he's starting to win me over. Based on what I just heard from Tony, I am starting to be very concerned that this left to its own devices will not go anywhere. George Tyler, go.
Sure.
You're breaking up, George.
George, unmute yourself.
He's unmuted.
Okay.
Type yourself in.
All right. We'll go to Mike Eggington.
Yeah, I was just going to say, whatever you all need, you know how long I've been doing this, working with the legislature, and when they overstep, the agencies overstep their legislative intent, we have to go back. And Irene, you used to go back on a regular basis and give Bob Smith an update on what's going on at DEP with the LSRP, and he typically does that. He has people come in and wants to know what's happening, what's the update, is it working from the legislation that they passed years ago. So I think it's high time. I think Chairman Kennedy over in the Assembly side should be notified of it. Maybe they have a joint committee hearing, which they typically do. The first course of action is talk to Smith, talk behind the scenes, say we need to have a remedy with this, that they're going off the reservation. And they get really ginned up when you say, hey, your bill did X, Y, and Z, and here's where we're at now, and it's totally beyond legislative intent.
Yeah.
And I'm happy to help with that, along with Tony Russo and any of the other usual suspects. But like I said, I think we're at a juncture now. You have to go back to the legislature and to the chairman and say, look, this was your baby and it worked for a while, but now it took a left turn at Albuquerque. So
Andy,
George.
who's on?
That was Tony. I'm sorry. I want to kind of just piggyback with Mike Eggington.
Yep.
And a couple of things, George. I want to be clear that I don't think he was defensive. In fairness to David Hames, I thought that was a good comment to say that the staff there shouldn't base decisions on their opinions, right? So I think he's agreeing with us that the staff there shouldn't provide opinions, but back up their decisions, right? And to Andy's point about bad submittals, I think, yeah, paperwork and you didn't do this or that is one thing, but I think we would be naive if we don't at least give the department an opportunity to tell us
Yeah,
in the stakeholder process,
yeah.
okay, tell us the cases that rise up to the top where you felt it wasn't protective, right? And then on the legislative side, and I'm glad Mike is on because, I mean, he knows this and everybody that's dealt with the legislature, this is such a subjective, nebulous topic that it ain't going to be easy crafting legislation to say, this is what we're going to do with independent professional judgment. It's a lot harder than what we did with Dirty Dirt or Sour 2.0. Because, okay, what is the ask, right? What is the language going to be?
Mhm.
And given the legislature and it's an election year, you're not going to get anything done this year.
Yeah.
You know, like, so just kind of keep that in mind that I think you got to give the department an opportunity here to fix it. And I agree with you. If it doesn't work with David at the assistant commissioner level, then with all the business groups, we kind of raise this up to Commissioner Latourette.
I agree with you.
Thank you.
Yeah, that's
We
a
got,
good
we got
plan.
George
I
Tyler
think
on.
George is back.
I'm going to try. Can you hear me now?
Yes, we can.
All right, good. I managed to fix the audio somehow, and I must say I'm intimidated speaking before such an illustrious group of experts in the area, but I'm going to try anyway. There are two things that I would suggest that maybe, with all due respect to what Tony just said, and I agree with him for the most part, maybe a couple of simple legislative fixes might help. One is, and I think George, you said this earlier, the reviewers should be LSRPs. Make them take the test, and that's a one-liner in a bill, and it sounds kind of reasonable, I would think, to a legislator. I think the department would go berserk, but it's a shot. The other thing that I've been confronted with lately is when the department tells an LSRP to withdraw a document, particularly an RAO, they just do it. Most of the time, they just do it. They don't want to confront the board. They don't want to hire an attorney, and I don't blame them for that. But that's an indirect way around the Administrative Procedures Act. The department says withdraw the RAO. The responsible party really doesn't have a right to appeal that or ask for a hearing on it or do anything with it. The RAO, it's a contract issue between the responsible party and the LSRP. So another relatively simple legislative fix, I think, that would bring some accountability to the process is make those decisions affect the responsible party directly, as well as, so if an LSRP withdraws the RAO, the person responsible for conducting the remediation has some rights in the administrative process. And that's something maybe Bob Smith would get his head around really quickly. And it's not a big bill either. So I just throw those two things out. And again, my compliments on the program. Good job. I'll just listen. Thank you.
And
Andy, your hand's still up.
And George,
Yeah.
if I can just say one thing before Andy goes, is because I said I'd say nothing today, is that piggybacking George Tyler, when you get a letter or get a comment from the DEP on permits, it clearly states this is not a final department not an action. Okay.
Final agency action.
Yeah. So the question was, well, if I want to appeal what they, and basically the answer I got was, you have nowhere to go.
Yeah.
Okay. I have one, we've gone to dispute resolution, but the assistant commissioner has to agree for it to go to dispute resolution. I'm not going to end up in dispute resolution. So I think George's comment is very viable.
Yeah, especially
Andy.
Linda Taylor and dispute resolution.
Hold on, Andy.
Mediation.
Andy, go ahead.
Yeah, so there are a couple of three things. One, I want to touch back, and if we have time, we'll come back to it. I think it's important for LSRPs and other practitioners to understand what George Tyler just said, is that the department does not have the authority to force anybody to withdraw anything. Sometimes it's very prudent to do that, not necessarily to withdraw, but to amend or otherwise revise. I mean, I don't know how many stupid discussions I've had about lot and block references, which are under law irrelevant to what the property is. It helps identify, but it's like your street address. They change the name of your street, your property hasn't changed. But beyond that, I think when you start talking about the legislative pathway, I think, you know, some of the concerns are, be careful what you open up. and ask for it, because I'm not sure the legislature is in a position to allow itself to be educated as to the nuance of this issue. I do think there needs to be pressure put, and I think the reason why we had the session the other week is because so many people have gone to the governor's office and to the commissioner's office and complained and noted and complained and noted. And the concern was that last week's listening session would be the end, saying, we listened, let's move on. I think that pressure has to be kept on. There are a number of ideas. I like some of what George said about his. We could push for an independent review board when there's a dispute on
There's a lot
a
of-
remedial
there are a lot
action.
of- In my opinion,
You know the reaction to bad and good police departments on independent review boards when it comes to their work, which is
Yeah.
incredibly difficult and challenging and stressful and dangerous work. I mean, you expect the department, but throwing the gauntlet out of saying, let's go to an independent review of LSRPs and department people who haven't touched this subject and go through and try to resolve that. I don't think that'll ever happen, but
Yeah,
it pushes the issue forward. But I think it's critical for everyone to know when to fight and not to fight, and the death by paper cut of, okay, I'll withdraw, okay, I'll withdraw, okay, withdraw, which on an independent basis makes sense economically and from a time perspective, is killing us.
Okay, so we're running short of time. Bob Lippincott, and we'll take it from there. Go ahead, Bob.
Yeah, I just had two comments quickly. Great discussion, by the way. The one is regarding George Tyler. I like the comments. I would offer and suggest that we consider going back to DEP at this point and just asking for something fairly simple regarding the determination to withdraw or request to withdraw from department review on an RAO. And I would ask that, I think this procedurally shouldn't be a problem, but that those go up the chain before they're sent, number one, so that it's not sent by anybody. It has to be reviewed by someone at some senior level. And number two, before they put that in an email ever, that whatever grievance they have or concern they have, technical, administrative, whatever, that they list them out and give you a reasonable amount of time to respond. Okay, because when they list their issues and our experiences, flawed retroactive appliance to guidance and things like that, and then say, so therefore withdraw. That puts you in a bind. That's different than just saying respond to these things, we'll work it out, and then if you can't work it out, then withdraw. I just think that they're adding that too easily in these emails. So that's one. Number two, and I don't think that's legislative. I think that's internal in the DEP. Number two, I think regarding Andy's comment, I agree overall, but I think that just saying simply under some of these circumstances to just to withdraw is an easy answer, is not an easy answer. There's situations with litigation and all kinds of things that is not in no way an easy answer. And for the LSRP or the PCR, and especially if it's under false pretenses or flawed review, and that's why what I just said I think is important. The thing is also that the department does have the authority to invalidate. So when they say withdraw, it's or else, okay? And they put sometimes unreasonable, in our experience, unreasonable timeframes on that, on very complicated issues.
Okay. I am very concerned, quite frankly, that there are so many fixes to this program that there needs to be a continual process in terms of taking these issues down one at a time. And Tony Russo has given the department 12 causative factors as to what needs to be fixed. And my concern is that this is going to fall on deaf ears. And if it does fall on deaf ears, I think we have to start thinking about what next. I agree with everybody. Right now, the nuclear solution should be put in abeyance, including legislative fix, in my opinion. I agree with Tony that we need to hear from David Hames as he comes back and see if he commits to a continuing meaningful stakeholder process. If he doesn't, I think it may be time to reconsider what we do and how we use it. And before we sign off, I'm going to give you a couple of items that were suggested to the department, but I want to continue with, we have 5 minutes left. Who wants to talk? Anybody? Irene, what do you think about all that you've heard right now?
I have lots of thoughts. But the thing that kind of is freaking me out is you guys keep talking about more training, more guidance, more documents, more discussions. And I feel we need to be bringing it back to the original conversations that we used to have about wearing the hat. You guys are wearing the hat. You guys should do the work. And the DEP should not be doing these independent individual reviews of everything.
Yeah.
I think there's two things to do. One, deal with the stakeholder process with the department, like you said, before we go legislative. But I wouldn't rely on the DEP to set up that stakeholder process if they're not going to move forward. Why can't you guys set up an LSRP oriented with all the different groups, stakeholder process, and do it yourselves? And put it together, the issues and the potential solutions.
Good
But
suggestion.
the thing that Neil said, just one thing, you and I had talked about this a couple of weeks ago. I wanted to know what the numbers are. If the numbers are as phenomenal as Neil said they were, what's the problem? That's what I would say if I was a DEP. And how much of those numbers are really LSRP, RAOs issued for large sites versus are they throwing in underground storage tanks and stuff in there again? So I think we still need to slice and dice data.
Good suggestions. Irene, why don't you tell us why you believe that the remedial action permit existed? What was the original
There
thought?
was only one reason, and that was to inform future state purchasers of the property that there were continuing requirements associated with that, because the NFA sounded like a final document. Nobody looked at with conditions. So the entire intent of the permit process was just to follow any ongoing requirements for future owners of that property.
And I think that gets lost in the shuffle. And I can tell, I have my own opinions as to why this happened. We have a couple more minutes left. Does anybody else want to be heard?
Roger has his hand up.
Roger always has his hand up. Go ahead.
No, usually I just jump right in. I'm welcome.
Yeah, I know.
I made a point during our presentation. I know we were focusing on professional judgment, but it's obvious that DEP's process is a large part of the problem. And I said, it feels like 2007 all over again. Writing 20-page response to comment letters,
Yep.
We had a term for those, invoked Saturday Night Live back in the day. But, it's like DEP's, couldn't manage 20,000 cases with 200 case managers. Now they can't manage 14,000 cases with 40 people, BRAP and BIR. So somehow, and we can't do this. They have to decide that they need to change their management paradigm to process things in a timely fashion and focus their resources on the really important stuff. And I know, it was apparent during Sarah 1.1, they are deathly afraid of another kiddie college being out there. That's why they need to know it. Everything has to be reported. We need to know. It's fear of that. And we need to disabuse them of that. And but they've got to decide that they need to reorganize how they do things. And that
Roger,
can only come from the 7th floor.
Yeah, I'm going to cut you off because we're running short of time. We have two people who want to talk again. First of all, George Tyler.
Thanks, George. I would just say I've heard the comments about stay away from the legislature and nuclear solution, but for what it's worth, I don't think anybody ever likes to regulate themselves. I think that's what Andy was talking about earlier. And you're going to run into that. It's good to keep the discussions going, but maybe a couple of conversations with Senator Smith with a small group of the folks on this call on your panel, perhaps, would get him to at least prompt the process that you want with DEP. If we just go in hat in hand and ask for it, it's going to take forever. But without introducing new legislation, he could certainly talk to the commissioner and push some simple solutions, like letting us go to the Office of Dispute Resolution and you know, that's always cut off, but that was always a good remedy for complex cases, things like that, just to get the process started. So I just wanted to throw that out as a sort of a middle ground.
George, I understand what you're saying. I have a terrible dispute resolution story that I'm not going to tell you. Andy.
Okay. Well, you probably had the wrong lawyer.
Obvious I did. It was Andy.
No.
Andy, unmute yourself, Andy.
That helps. So I think what we're hearing is that the department has their priorities in reverse. They should be supporting LSRPs by getting the ARS approvals in there, getting critical feedback on really difficult technical issues when they happen, issuing RAPs instantly. And then down the line, you push for corrections. You refer LSRPs who are submitting deficient stuff. You go after PRCRs who haven't done remediation correctly. And then only if you have information that it's not protective do you push for invalidation or withdrawal if there's a compromise to withdraw and reissue. That's the opposite of what they're doing now. And how we get there, I think there are multiple approaches. Having a session, let's see how the stakeholder session plays out, if it plays out over the next couple of weeks. And maybe there is a great idea to let's have our own session, invite DEP, and invite Senator Smith to it as we go through the process. I think we need to keep the pressure on. Yes, there are bad submissions that need to be addressed, and that's a separate issue entirely.
Andy, I want to say, quite frankly, I'm sorry, Andy, I stepped on you. You done?
Yeah, I'm okay.
Okay. One of the things that I find somewhat disappointing, and this is for somebody who's on this call, is why the board hasn't taken this issue on. The preemption, one of the roles of the board is to protect the LSRP from specious issues. And I am concerned that the board is blind to this particular issue. And I do believe it's subject to a discussion with the board and seeing how they respond. Because what's happening is every time you certify a submission, and it's really DEP's opinion, not yours, you're falsely certifying that position. So my position simply is, where's the board on this? And should the board have more doing? Go ahead, Phil.
So I did raise my hand. I don't know if you're talking about me or not.
I am talking about you.
But just two things. One is at that session 2 weeks ago on your birthday, Paul Stofa, who is now the chair of the board, was there wearing both hats representing Deputy Commissioner Sean Moriarty and the board. It is something that we are talking about at the board level as to what our involvement will be. So
excellent.
It is not going upon deaf ears, but I will say something as not that I'm representing the board anyway, is I mean, I'm going to agree with what George Tyler said, agree with what Andy just said. But I think the one thing is, I think we do need to move fast because the department is moving forward with their rules proposal. Supposedly there was a stakeholder process in the next 30 days. I keep hearing about, but I haven't seen an invitation yet. I heard it yesterday again. And, Mark did say way back when, Peterson, we're going to fix this with a regulatory fix. I would hate to think that we get a regulatory fix that isn't the regulatory fix we want, because the stakeholder process that we're going to see is not going to be what we saw historically. We know that's a fact.
What rule is this, Phil?
This is the tech regs, ARCs and everything.
I'm sorry, say again.
This is tech regs and ARCs. This is, the rules. This is what needs to be updated from Sarah. I think we need to move fast. We can't let this die. Whatever we need to do behind the scenes, in front of the scenes, whatever, because if rules get proposed and the process continues down the road, it's not going to be what we're talking about that needs to be done.
Okay.
I'm going to jump in, George, because we specifically.
Roger, we got to.
Let Roger.
No, this is
Roger's in the
George, this is
room.
important.
Go.
This is really important.
Okay, so listen.
No, let Roger go, George. Let Roger go.
What?
Last drag meeting, I explicitly asked, can we see draft language?
No, they said no.
We did this with the tech rule when we rebuilt it. We did this with the remediation standards, and it worked. We were told that it is now department policy that they cannot share draft language.
Okay,
And we would expect to see the language in the fall, as part of a rule proposal. I want to know where in the Administrative Procedures Act it says that. What are they standing on? And it's been crickets. And I know Rick Engel was on our list of attendees. I don't know if Rick has heard of this or, but I'd ask for an opinion. Where is this coming from? If this is coming from the commissioner's office, who and why is this coming down? Because this is not a transparent stakeholder process at all. This is a complete failure.
okay. Thank you to everybody. Thank you to the panelists particularly. Thank you for the great comments from the attendees as well. Phil and I do these hot topics, not because we make money, because we don't, and we're not intended to. We do it because we think we should. And we have 60 people on this. I really appreciate your attendance because I think having this synergy in terms of hearing from you all will help us formulate fixes. Tony Russo has given at least 11 fixes to the existing problem. And then real quickly, relative to RAPs, guidance manual for the reviewers. Relative to the developing categories for permits based on the experience of the reviewers, Cat 1, Cat 2, Cat 3, based on complexity. Use of permit by rule or general permits, particularly for the Cat 1 categories. Assign reviewers based on experience in accordance with the permit application complexity. Develop flow diagrams, develop decision matrix, and establish a meaningful stakeholder process. So this is but one of 11 recommendations that Tony made during our presentation. Thank you so much. We have work to do. This is not even the beginning anymore. We're past the beginning. Now it's time to do something meaningful. And I am committed to doing whatever it takes to fix this problem. Thank you, one and all. We appreciate it. Everybody have a good weekend. Watch out for the fog, and we'll see you soon. Thanks again.
Thank you to our panel. Great job, everybody.
Great panel.
Appreciate your time. Good job.
Thank you.
Thank you.
Thanks.
George, drive carefully.